Well, for more on the story, we're joined by legal expert Mpumelelo Zikalala. Good evening, Mpumelelo. Thanks for your time. Is Judge Maumela right that the introduction of the so-called second docket has created chaos, confusion for this trial?
Definitely, but what is even adding more to the confusion is the strategy by the NPA of saying you have pieces of evidence. In this sense, it is witnesses that have deposed to affidavits dealing about the facts and the merits of the matter, in which the state is saying we're not going to give willy-nilly to the defense, or we're not going to make those part of the evidence as part of the proceedings. Now, what then it goes to is it then says, on what type of information must I work with? As the defense, I work on whatever that the state has given me. The state is supposed to come with all the things which is going to be used and assisted. This is going to assist in getting us to the merits of this particular matter. If we're not going to do that, we are going to cause problems for us, which is why the legislature at the time of drafting the Criminal Procedure Act thought of a section 317 section of saying, if there are instances such as these ones, allow the defense to make an application in which it raises and places on record this type of irregularities that at the end of the day, when accumulated or looked at in its entirety, may lead to the fair trial rights of the accused being infringed. So that at the instance where the state has finished its case, a section 174 application can be made. At the stage where all the parties have finished giving their evidence and we're waiting for judgment, those particular irregularities can be raised. Or, and at the appeal stage, you can even raise them and say, the state has not played a fair game in this particular instance. I was litigation on situations in which information was being hidden from me that could have assisted me in terms of attaining my freedom.
One of the interesting points that you've made, Mpumelelo, in another conversation is that ultimately the defense at this point may not necessarily be trying to get the case thrown out, but it really is about what it's going to use the current moment for when it comes to that critical point where this court has to make a finding of innocence and guilt against these accused.
Definitely. I think the point of Advocate Zandile was not to say I want my client to be released and be found not guilty. Of course, that would have been first prize. However, I'm building a case here of inconsistency. I'm building a case here of an NPA which is preparing its case in an unprofessional manner. Lots of irregularities which are going to come into place. There's a lot of evidence which is going to be hidden. They're not allowing the court to make a proper discussion of proper determination of whether the evidence in front of it is one which can be utilized, and also going into the credibility of the witnesses that are there. The most important question would be, why would the state hide information which at the end of the day may have the potential of exonerating the accused which are in the witness box? If you go and you are litigating in this type of matters, as the judge was saying earlier, pre-trial conferences are held for a reason. They are there to make sure that the state is able to disclose all the statements and witnesses in which they are supposed to use. Even the Criminal Procedure Act and case law would tell us, you even disclose information which is going to be adverse to you, which has the potential of actually freeing the accused in this matter. It's all based on the principles of fairness, but most importantly, the protection of the accused rights per Section 35. If there are certain instances of unfairness which are going to be identified during the trial, the judge will be forced to say, there may have been instances in which we are supposed to answer on this type of questions or in this type of the evidence which is in front of me. But due to the injustices that have taken place, I have to acquit you as the accused.
Mpumelelo, let me put you in a bit of a complicated position, advising then the accused in this matter. If you were their lawyers, what would be some of your next moves?
I would say continue with the current strategy that you have. You have been given access to the second docket. It contains witness statements that are there. So whenever a witness would then come in and there's a potential witness is not going to be called by the state, the first question would be, are you going to call this witness? Can I subpoena them so that they come and give evidence in this particular court? That particular evidence is going to be in contradiction with the state witnesses. That's creating doubt. Let's also remember what you are driving to with all these litigations or with all the witnesses that are going there. The state has to prove beyond reasonable doubt that the accused which are in the witness box are the real ones that are the actual perpetrators. The only way in which it does that, it says there's no other explanation except the explanation which is provided by the state as to how the sequence of events took place. If you create doubt, if you have other alternative meanings or other alternative explanations that you could bring into the fore, it means that the very high test of being guilty beyond reasonable doubt would not be achieved by the state. So continue doing what you are doing now, and maybe at the end of the day, things are going to go your way.
Unfortunately, Mpumelelo, just to wrap it up here, things are not looking good right now for the state in as far as the ability to be able to secure a conviction, and really the test being that of beyond reasonable doubt.
Not at all. And you see, in order to save this particular matter, what they were supposed to do is take the two dockets, mirror the evidence in the witness statements that they have, see where they collaborate each other, see where the differences are. And where there are differences, ask yourself this question. Is it an honest mistake of not remembering what happened on the day? Or is it an instance where someone was lying, trying to mislead us? If that's the case, bring them in as co-accused and bring the doctrine of common purpose into the fore and say, your involvement in this matter, whether directly or indirectly, whether it was intentional or not, lying to us as the state and leading us into astray instead of telling us the truth, has led us into the situation that we are in now. So we are also going to charge you with acting in common purpose with the accused, or perjury, which is an alternative charge that you can also add. And then at the end of the day, you'll be able to acquire a conviction. If you wait up until this trial has been done, as suggested by the state, we are going to run into problems because people are going to go into the witness box, incriminate themselves, but most importantly, you will get them on a lesser crime. You want to make sure that you want to find the truth for the Meyiwa family, and the only way to do that is to make sure that bring all the individuals that were there to come to the witness box to tell us the truth as to what happened on that fateful night.
Legal expert Mpumelelo Zikalala, thanks for your insights tonight. We'll leave it there.